law gets repealed. Void नहीं है, repeal हो जाता है 1950. Pending prosecutions will continue and you can still give a judgment in 1952. So, in the case of judiciary, when I say it is, the cause of action is the crucial date, not the date of delivery of judgment. And therefore, you cannot develop the kind of argument that you are trying to develop. This is always the case. So, for example, let me take a more concrete example. TADA, Terrorist and Disruptive Activities Act. It's a law of 1987. It got repealed a few years later. Nowadays, we have UAPA, okay, Unlawful Activities Prevention Act, more or less like TADA. Now, yet, though it got repealed, prosecutions continued under it. So that's my response to you. So the judiciary has only to interpret, and unfortunately, 13(1) is given a prospective holding. Now, why did the Constituent Assembly not give it a retrospective? You could ask this question. And I think that the answer is actually quite straightforward. If they held it to be retrospective, then all actions taken prior would be rendered null and void. And any conviction, any death sentence, for example, Bhagat Singh. Bhagat Singh was charged with section 131 of the Indian Penal Code, which is waging war against the Indian state. Okay? It's a very rarely used provision. Remember 131. 124, capital A sedition is far more frequently used then and now compared to waging war, because waging war means that you have picked up arms and you're waging an armed struggle against the Indian state. So in fact, I think after Bhagat Singh, perhaps the next time it was ever used in Punjab was with Bhindranwale, who was charged with 131 when Golden Temple was stormed in 1984, 4th of June. Okay, and he had been charged in 131. Now, if the Constituent Assembly had taken 13(1) to be retrospective, I think the political fallout would have been profound. Because what would then happen is, all convictions that had taken place in the past, and I'm using the Bhagat Singh issue as just as a dramatic example of the same thing, would then be declared as illegal. And these would be then judicial murders. So it would be very difficult for them to give in retrospectivity. So they accepted the colonial rules and then said, henceforth, it will not be valid if it is in violation of a fundamental rights. Okay? So this is the position that we see. Now, the power to repeal the laws, and also he also had the power to give a notification that under the repealed laws, all the pending prosecutions will be null and void. He could have, yes. Had such an order come, would it have been challenged under Article 14 as contrary to Article 14? I see your point. I have a feeling because around the same time the court was also developing its doctrine of classification. And I think they have found sufficient nexus to say that those people who were before should be brought onto the same footing as those subsequently who could not be charged with because now the law is void. I think that they could have made a case. It's hypothetical, of course, but I think that they'd have had a fair chance of winning. Ma'am. Which is why says that, look, you cannot expect what you are asking from us. Your political aspiration has to be met by the executive, not by us. And that is something, let me just make one final point and stop here. If you look at a lot of constitutional writers, academic writers, they talk about the fact that the increasing role of the courts results in what we call juridification of disputes. This is a word that is now coming into more common currency in the last 30 years or so, juridification. That is essentially political questions you throw into the court, because it's easier if it were couched in a decisional form or judgment form and comes back to us. I mean, it doesn't surprise us at all. Right? It happens all the time in India. So the juridification of disputes is there, but the more and more the courts exercise judicial power, in the long run, it politicizes the judiciary itself, and in the long run, it reduces its credibility. So you can see the tension. You would like the three arms of the state. The judiciary becomes, you think it becomes more powerful when it starts taking up more and more cases, holding actions by the executive or legislature to be null and void, acts on the sentinel on the qui as Chief Justice Patanjali Shastri mentioned once. Yet it comes in at a long-term price. So the link between greater activism, greater juridification, resulting eventually in lesser legitimacy, is something that has happened in many states. So there's no avoiding it, because you can't avoid the kinds of problems that get thrown up in real life. But we can also do. Now, in response to your question, Vineet, is there any relief possible for the people who have been convicted through the president's power? Yes, he could have. He could have said that there is a general amnesty being given, or if not to everybody, at least for those who are charged with political offenses. Now, please remember, between 1949 and 1951, in those 2 years, state after state enacted public safety laws. Okay, and when I come to Ramesh Thapar and Brij Bhushan in Article 19, you will notice that these public safety laws were used essentially against the press to gag them. Okay, and obviously, if you are a journalist, you're a political person, you're a political prisoner, you're not like a murderer or a rapist or something. You hold a view, ideological or political position, which is at variance. And so these laws are used. The president could have done that. But as I told you, the remedies for people who had earlier been convicted was found through the executive, through the institution of pension, honoring people who were freedom fighters. So it's only very, very recently that, Satluj Ke Kinare, there is now a memorial to that thing. It took a lot of time. It took more than 60 plus years for that recognition to come. Okay.
Ma'am, I have a question.
Ma'am, in this case, it is not possible for a Supreme Court to act on an analogy like the president acted in a pocket veto and on the judgment for a long time.
No.
For indefinite time. What is that?
By the way, I understand. For complete justice under Article 142, the 5-judge bench in re V.C. Mishra, I think I mentioned it last semester. This is a 1995 case. Okay. And in that case, of course, we are talking about 50 and I'm talking about 1940, but the principle is the same. Where a power has been given to somebody else, the Supreme Court cannot use Article 142 to exercise similar powers. It can only exercise those powers when such a power has not been allocated either to the. So in V.C. Mishra, what happened is that the court decided to disqualify the president of the Uttar Pradesh Bar Association for his very bad behavior in the court. But then later on, it was found that the power of disqualifying a lawyer and taking away his license is given only to the disciplinary committee of the Bar Council under the Advocates Act 1961. So once a specific power has been conferred on somebody, using 142, courts cannot usurp that. So by analogy, since the power to modify, amend, etc., has been given to the president, Supreme Court using complete justice under 142 cannot do that. So you can't use 142 as a gateway to, intrude on powers given elsewhere. Okay, somebody else had a last question. We can't go on.
Yes, ma'am. Ma'am,
Yes, go ahead.
repealed statute are garnering its power from Section 6 of General Clauses Act. But where does it mention that temporary statute, once it comes to an end, that all the conviction will be set aside? Unless and until there is a...
Yeah, we discussed this yesterday. So let me show you those words which is there. Okay, so you have to read the Keshava Madhava Menon's case and look, it's there, and as a general principle of interpretation. So let me see if I can do that. If somebody is quicker than me, my computer is working there. Please just read out those lines. Here we go. If you look at paragraph 13, sorry, look at page 54. And that principle from 249 to 53, 57, 369 is there. So please read it, whoever asked the question. Okay? It's not drawing from the General Clauses Act. It is drawing from the principle of how temporary statutes operate. And if you want a further elaboration of it, please look at the Krishna Kumar Singh versus State of the Art judgment. Okay? I don't think I want to spend more time on this now. Now let me now move on to Article 13.2. 13.2 is like am I audible? Can I continue, please? Yes, ma'am. You see, there may be many questions, but just let me go ahead and then we can, if required. But for those of you who asked that question, please look at paragraphs 13 and 14, the answer which was this here. Now look at 13.2. The state shall not make any law. It's a mandate to the state. Shall not make any law which takes away or abridges the rights. Takes away or abridges. Takes away means completely taking it away, negating it. Abridging means that it is diminishing it, while some rights may remain, some may be taken away, or part of some right may remain and part may be taken away. Abridging the rights conferred by this part, and any law made in contravention of this clause shall, to the extent of contravention, be void. Now, in 13.1, we use the word inconsistency, and in 13.2, we use the word contravention. Why is that? Because contravention is because there is an express prohibition in Article 13.2 that you shall not make a law which is in violation of fundamental rights. And if you make a law in violation of fundamental rights, then in contravention of this mandate, then the law is void. Is it entirely void? It is only void to the extent of the contravention. In 13.1, the law gets made before and then the constitution comes. Then a law which is inconsistent, similarly to the extent of inconsistency, is void. Why contravention in 13.2? Because first the constitution comes and then the parliament dares to make a law which is in violation of fundamental rights. Then this law to the extent. Now the word to the extent gives us the doctrine of severability. In Keshava Madhava Menon, the doctrine of retrospectivity or prospectivity. Extent, that word, to the extent of inconsistency, gives us the doctrine of severability. Now, doctrine of severability, very nice example would be F.N. Balsara versus State of Bombay. And the long and short of it is this. The entire law is not struck down, but offending provisions or sections are struck down. If that which is in violation is the central provision or the charging section of the law, then of course the entire law will have to fall. And one of you gave a good example, yes, last class, the NJAC Act, which had a collegium system at variance with the collegium system as evolved in the third judge's case. This collegium system under the Act, NJAC Act, was deemed to be violative of the basic structure of independence of the judiciary, for instance. And therefore, the amendment and the act were completely struck down because there was nothing left. If you took away the collegium system, the others were, powers, sitting, what are they? Very minor matters, so nothing of substance remains. So the entire thing went. But by and large, what you find is doctrine of severability is used to cut away the offending provision. There is yet another technique which is used, which is to read down. But reading down is different from the doctrine of severability. In reading down, as students of law, you're well aware of, you give a slightly limited reading to a certain phrase in the act in order to completely hold the entire law constitutional. After trying for reading down, if you still are unable to save the law, then you will have to move to doctrine of severability. So extent of contravention, extent of consistency tells us enough about the doctrine of severability. Okay. It shall be void to the extent of severability. Now, Article 13.2 and Article 13.1. So let me begin with 13.1. There is also yet another doctrine called the doctrine of eclipse, which is sort of hidden away in the shadows of Article 13.1 and controversially in 13.2. I'll tell you why I'm saying 13.2. Because if you read Professor N.P. Jain's book, he holds that the doctrine of eclipse can only be located in 13.1. It cannot be located in 13.2. If you were to read Professor N.P. Singh's book, Constitutional Law, B.N. Singh's book, then Professor N.P. Singh argues that on the basis of Ambika Mills, that eclipse can also apply in 13.2. Professor M.P. Jain believes that Justice Matthew's judgment in Ambika Mills is incorrect. Okay, so depending on the book that you read, you will find either eclipse hidden only in 13.1 or you will find eclipse both in 13.1 and 13.2. In Delhi University, we have always followed Ambika Mills. We read that judgment, and I, for one, think that Justice Matthew was completely correct, and I actually disagree with N.P. Jain on that point. Okay, fine. You'll understand more. I've told you the end conclusion so that you can understand when I tell you the reasoning where we are headed. Okay, fine. Now, what is the doctrine of eclipse? Exactly like the physical phenomenon of an eclipse, that here is the sun, a shadow falls on it, and therefore the sun gets hidden. But when the shadow passes, the sun again comes back in its full vigor, in proprio vigore, in its full vigor. I'm using this expression because it's used in the judgment. Okay. Now, when it covers, there is also penumbra. And when I come to Article 19, we will be using that expression of penumbral rights and core rights. Okay. So the solar eclipse, so the lunar eclipse, gives rise to two doctrines of constitutional interpretation. I've always found it actually quite interesting that the eclipse should affect it's actually quite. And then there is, of course, another one, which is the brooding omnipresence in the sky. So I borrowed it once when I was writing an article in the Journal of Indian Law Institute, but just as an artistic and an aesthetic feature of the Constitution. I like it. Now, here is the eclipse. What is the eclipse? Now, let's take 13.1 because it's easier to understand eclipse in 13.1, and then I'll come to Ambika Mills. Now, who has fundamental rights? So I think that should be my starting point. If you were to turn to Article 19, it's only citizens that have fundamental rights. Why do I say this? Because the opening words of Article 19 says so. It gives these all-important freedoms like speech and assembly and movement and trade and business to citizens. Technically speaking, if you are a non-citizen, you cannot enjoy those rights. Now, non-citizens can be in two categories. You can have natural non-citizens or natural persons, okay? Or you can have artificial persons who are also not citizens. And the artificial persons would, of course, be companies. So, if I am a non-citizen, either because I'm a human being or because I'm a company, I cannot allege that my fundamental rights have been infringed. Till 1969, the view was, therefore, a company could not allege violation of Article 19 rights. And this proved to be a problem because nowadays the media houses are all corporate houses. And if the government were to place a gag order on Twitter or WhatsApp, you know that there's this petition that our own colleague has filed on WhatsApp. And suppose there is an order saying WhatsApp cannot have its privacy policy, or Twitter has been told face consequences and remove that hashtag with regard to the agitation, etc., etc. Twitter is a company. WhatsApp is a company. Bennett Coleman is a company. Republic, our own Arnab Goswami, is a company. And if you say that Article 19 rights have been infringed, can they file a writ petition or not? Till around 1969, the idea was that a company could not file a writ petition under Article 32 saying that their fundamental rights were violated. They chose other remedies. I'm not going to that, but they did have. They were not remedy-less, don't worry. But after the 11-judge bench decision in 1970, R.C. Cooper versus Union of India, also known as the bank nationalization case, the 11-judge bench said that after all, what is a company? A company is a bunch of individuals. So they said, koi baat nahi, Solomon versus Solomon, rehne do. We will lift the corporate veil and see behind the company are individuals. And if those individuals are citizens, they went on very famously to say that when citizens who have Article 19 rights come together to form a company, that company necessarily should be deemed to have those fundamental rights. But because the company has no standing because it's not a citizen, a writ petition can be maintained provided the second respondent, first respondent will be the company, but the second respondent or the second petitioner, will have to be a human shareholder who is a citizen. And so with this very elegant little remedy, you find that corporates now have the right to file petitions saying that their freedom of speech and expression is hampered. So you can take Republic TV, you can take NDTV, you can take Times Now, you can look at Bennett Coleman, Indian Express. These are the major litigators on press and freedom. And they all come to the Supreme Court under 32. They all file petitions, but because they have clever lawyers like you people are likely to become, they see to it that in the joinder of parties, that the second petitioner is always a shareholder. Okay, fine. Now, here you have a company that is a non-citizen and you have a citizen who has an Article 19 rights. Now, the Supreme Court in Bikaji Narayan Thakras makes the point that if there is a pre-constitutional law which infringes, let us say, Article 19(1)(a), after the coming into force of the Constitution on 26/1/1950, that part of the law which is applicable to citizens is void. But that part of the law which is applicable to non-citizens will continue. Now look at this doctrine and see why it is different from doctrine of severability. Under doctrine of severability, the offending section, so let us say an act has 10 sections, maybe section 2, which is offending freedom of speech and expression in its entirety, is void. Doctrine of eclipse doesn't say a particular section is void. It says it is void with respect to citizens, but continues to be valid with respect to non-citizens. So whereas in severability, you may have come to the conclusion that an entire section is void and therefore unenforceable, Bikaji Narayan Dhakra says, no. If it is 5, that section 5 of this act is just some number pulled out, okay, nothing specific. If it's section 5 of the act that is in violation of fundamental rights, it will continue to be valid with regards to non-citizens, but it will be void only with respect to citizens. So there is a partial voidness vis-a-vis citizens and a partial continuance of validity with regard to non-citizens. This nuancing of severability is the doctrine of eclipse. So there is no one answer for all categories of persons. सबके लिए void है, ऐसा नहीं है. Extent of contravention, void to the extent of contravention is depending on who is asking the question. If it is a citizen asking the question, yes, it is void. If it is a non-citizen asking, is this provision violating freedom of speech valid or void? And the person asking the question is a non-citizen, a company, then the answer is, sorry boss, aapke liye to valid hai, void nahi hai. Which means that it has this half-life. It's not fully dead, but it is only, as this lovely word, it is only moribund. If tomorrow there is an amendment and Article 19(1)(a) goes away, then the shadow disappears and the article will be valid in its entirety, not only for the non-citizens, which it always was, but also for citizens. Because it has this capacity for rising like a phoenix from the ashes, because it has this capacity for, reincarnation, as it were, we have to say that it was not fully dead and gone. There was a shadow over it. But now that the shadow is gone, the eclipse and the law can revive in its entirety. Now you'll see that the introduction of another doctrine, the doctrine of eclipse, makes the whole notion of voidness much more nuanced and sophisticated. According to the doctrine of severability, you either have black or white. It's fully void or that section is fully valid. Now with doctrine of eclipse, you can have saying void with respect to one set of people, valid with respect to somebody else. Okay. So, who is it who has prepared Bikaji Narayan Dhakras?
Ma'am Rini.
Rini, can we just run through the facts only with this? I hope other people have read. Yes. Yeah.
I have a question. If suppose there is a company consisting of 3 persons.
Is your question about eclipse?
Yes, ma'am.
Can I just have Rini? Can I have Rini please first with the facts? Because I think then it will make sense. Then I'll take your question. Not a problem.
Sure,
yes?
Sure, ma'am. Ma'am, could you please repeat the 1970 judgment, 11th and judgment?
R.C. Cooper versus Union. R.C. Cooper. Rustam G. Kovas G. Cooper. Cooper. Okay.
Thank you, ma'am. May I begin, ma'am?
Yes, please.
So now in Bikaji Narayan Dhakras versus State of MP, 5 petitions against the state of Madhya Pradesh were clubbed by the Supreme Court, and they challenged the validity of the CPN Birar Motor Vehicles Amendment Act of 1948.
Mm-hmm.
the Act of 1948 basically amended the state law with respect to motor vehicles in the state of MP, and they introduced certain restrictions with respect to the running of the business in the plying of buses. So they fixed the maximum and minimum fares with respect to stage carriers and public carriers, and they also declared that they could introduce a state monopoly if they wanted to. Now, this was in 1948. In 1950, we had the Constitution, which introduced fundamental rights under 19(1)(g), which gave the fundamental right to practice any trade or profession, and which could include the right to ply buses under the Motor Vehicles Act. And this Motor Vehicles Act amendment of 1948 of the Madhya Pradesh state, it was not protected under the clause 6 of Article 19, which provides for certain restrictions, reasonable restrictions to 19(1)(g). Now, in 1951, there was a constitutional amendment which amended clause 6 of Article 19. And it introduced that the state could enforce a monopoly in any business, which inter alia included the motor vehicles, the same that is being contended in the petition. Yeah. So the court held against the petitioner's contentions that the court held that the law of 1948 was only eclipsed until the amendment of 1951. By the coming of the Constitution in 1950, a shadow was cast upon the 1948 amendment, which was lifted in 1951, and the state monopoly that was enforced by way of 1948 amendment was thus valid after 1951.
Okay, good. Now, which is the law we're looking at?
Ma'am, this is the...
which is the Parent Act? You talked about the amendment of 48, but which was the Parent Act?
From the Motor Vehicles Act.
Yeah. (1939)? It doesn't matter. 1939. So the amendment. So I hope this is clear to everybody, Rini's facts. Law, an amendment in 1948, pre-constitutional amendment, which allows the government to have a monopoly in stage transport. That is public transport moving people, say from Delhi to Meerut, whatever. Then 1950, Constitution, freedom of trade and business. This amendment of 48 therefore deprives people of the road opportunity to do road transport business. Therefore, void to the extent of its inconsistency. But the first constitutional amendment introduces the proviso to Article 96, which says monopoly is also a valid restriction. So, the fact that normally reasonable restriction means that you leave some of the right, but you're restricting part of the right. A monopoly on part of the state means you are completely erasing the right of a private citizen to take part in that business. But the first amendment holds a state monopoly to be valid. Therefore, in 1952, after the coming into force of the First Amendment in 1951, the question is whether the law is valid or void. And therefore, Rini, my question to you is, once it became void with regard to citizens in 1950, was there a need for legislature to reenact it, or did it become alive and valid on its own?
Ma'am, there was no need to reenact it because the law was only eclipsed for the time being by the clause, by 19(1)(g).
Right. Now that brings us to an important question, because if you believe that this was only a shadow and the shadow passed and the law has again revived, then reviving does not require fresh enactment, which means when you use the word void, and if you look at Justice Venkatramayar in the Sundramayar's case, which is cited in Bikaji Narayan Dhakras, we have another judgment of the Supreme Court which says that the word void, as used in Article 13, has a different meaning from the word void used in Article 245 and 246. And the same word in the same document have a different meaning in 13 as compared to 245 and 246. And this is the question that is being asked now. Did you read up on this point, Dini? Are you in a position to answer my question on this?
Ma'am, I couldn't identify the case that you were talking about.
Okay, who has read Ambika Mins? Who had prepared Ambika Mins, please? The students not here? Okay, but let me try and explain it to all of you. Look at Article 245 and 246, okay? What does it say? It says that if Parliament makes a law with regard to a matter in the state list, and now no emergency, nothing is there, none of the provisions of Article 249 to 50, 51, 52, 53 are available, fine. Then the law has to be void for lack of competence. If a law is void for want of legislative competence, is it void from the date that a court has declared it to be void, or does it become void ab initio? This is my question to you. And I'm asking you another question. If two people who are Sapinda relations get married today, and then 3 years later somebody challenges it in court, and the court gives a declaration under Section 24 that it is a void marriage. Is it the position that the marriage was void ab initio, or does it become void 3 years later when the court declares it to be void? What is the timing of void?
Ma'am, it was void ab initio.
Bad or void or ab initio. That is, it relates back to the original moment and therefore void ab initio from its very instance. Now, when a law is void, yes, please.
I would like to add to that, regardless of the court's declaration, the marriage would be void.
Exactly. It's void ab initio. So, in fact, the declaration by the court is only the icing on the cake. But it is a moot point whether a person who gets married again after having got first married voidly in a void manner to a Sapinda relationship, he or she would be an extremely bold person to go ahead and have a second marriage, because there's always a chance that the first person may charge him with bigamy. And in which case, in defense, the defense will have to be that my first marriage was no marriage at all. It was a bigamous marriage, right? And therefore, as a lawyer, whoever answered, I have to say as a lawyer, you have to be prudent and tell your client, "Hanji, void to hai. फिर भी हम जाकर कोर्ट में एक declaration दे आते हैं. It will be better for us. Because otherwise that poor client can never get married. Always, वो मंडराया रहेगा कि आपने bigamous marriage तो नहीं की, right? You agree? Yeah. Okay. So the thing is, there is the law, but there's also the client and what advice you would give, what would be the prudent advice. Because, when you say it's void, I don't need to do anything, then, anyway, let's not go into that. So it's void ab initio. Now, those of you who have read Ambika Mins, another very good judge of the Supreme Court who was there in the 1950s, T.L. Venkatramayar, wrote in Sundramayar's case, and it's cited there in Ambika Mins. Okay, I just have to look it up. And this judge of the Supreme Court made a point that while voidness in 245 and 246 is void ab initio, when you apply the doctrine of eclipse, as was done in Bikaji Narayan's case, and you declare it to be void, This void is not void ab initio, but it is only void, as he put it, unenforceable void. It is not void ab initio. And his logic was, because once the eclipse goes and the law once again revives, to say it was void from the very beginning becomes meaningless, because then we would have to reenact it once again after the First Amendment. Now you will have to say, acha, we can make a law which provides a monopoly. फिर से वो bill introduce कीजिए and let us again enact a law. You would have to do that, because if you had subscribed to the view that the word void means void ab initio, but because we are subscribing now to a doctrine of eclipse, necessarily it requires that the law cannot be seen as dead or non-est. I'm now using two other words, dead and non-est. Non-est meaning that which does not exist. Okay, dead means like dead as a dodo. It's just no chance of its survival. But because eclipse includes an idea that the law can revive, the revivification of a law implies that it was not dead but moribund. That is, it is in some kind of a sleepy state, and it could revive once the shadow can pass. And if it has that capacity for revival, it means that at the initial stage it was not dead and gone, but it was only in some sleeping, like a sleeping beauty, and waiting for the kiss of life which would come from an amendment. And that's really what was happening. So Justice Venkatramayya drew the distinction and said void under Article 13.1 is different from the nature of void in 245 and 246. He said that
they use the word invalid, not void.
Is it so? Let me check. True. I accept that. Yeah. That's true. So 246. Okay.
Even 246, there is no use of the word void.
No, it's no use. But when we say the effect will be that it's invalid, the nature of the voidness would be void ab initio. So suppose the state legislature was to make a law with regard to a union list, and then it was challenged for want of legislative competence, then it would have no effect at all. And unless a separate law was passed saving the steps that were taken, all the actions taken under an invalid law or void law would also be void. Now, this distinction that the nature of void is ab initio there, but it is only unenforceable here, has been a very controversial position. Okay. So, if you look in the Krishna Kumar's case of Bihar, Justice Chandrachud has enumerated all those places where the word void is used. You can just have a look at it. It's quite interesting. In the Bikaji Narayan case, they were dealing with a pre-constitutional law. Now, Professor N.P. Jain takes the view that there cannot be any difference to voidness whether it is in 13.1 or in 13.2. In 13.1, a pre-constitutional law which is void because of inconsistency with the constitution has to be treated as either in its entirety void or by applying the doctrine of severability to say that offending section is void. And once it is void for the whole world. The only bit of eclipse that you can use is that after 1950, the law will continue to be valid for those people who do not enjoy those fundamental rights, namely the non-citizens. This is assuming we are talking about an Article 19 case. Okay. Yet, if we are not talking about an Article 19 right, but we are talking about an Article 14 right, then there can be no doctrine of eclipse. Because whether you're a citizen or a non-citizen, everybody enjoys Article 14. So the doctrine of eclipse can only apply to those fundamental rights which are limited to a subset of people in India, namely citizens. But Article 14 and 21 could never ever have the doctrine of eclipse because they use the word person. And person, as you know, is broader than citizen. Now, Professor M.P. Jain takes the view that the nature of voidness in 13.1 and 13.2 is the same. And if it is the same, then because 13.2 uses the word contravention, because 13.2 says no law shall be made by Parliament, sorry, just 13. The state shall not make any law which takes away or bridges the rights conferred by this part. This is an embargo on the state. And even if the state shall make a law only with regard to citizens or with regard to persons, because of the language of Article 13.2, because there's an embargo on the state, it should not have made a law with regard to citizens. And because of this, the entire law will be void and therefore there cannot be a doctrine of eclipse. But in contrast to this view, which is a very conservative view of Professor M.P. Jain, you find a little more liberal view in Justice Matthew's judgment in Ambika Mills case. Okay. Now it's 11:30, so I should stop here. But I'd like to take the class tomorrow, please. Okay, can I take the class, tutorial class? Have you fixed up anything else? No, because I think I would like to finish Ambika Mills, and I've lost 2 classes last week, I think, for the internet. So I will be taking class tomorrow. Priyasha, are you there? So please post, or I'll have to post saying I will be taking class there. Okay. So,
Ma'am,
yes.
ma'am, the basic argument of difference between 13.1 and 13.2 on the nature of voidness would be that 13.1 operates for only post-constitutional laws. And in 13.1, it would declare the law void. And in 13.2, it would declare the law void ab initio, isn't it?
Yes.
But I think I want to say something else. And so let me answer this tomorrow. Okay? I don't want to have a yes-no answer. I don't think that's enough.
If we have by mistake missed some of your lectures, can we access it anywhere else?
No, it's not
Is there
been
any
taped. It's not been taped, sorry.
Thank you.
Okay, just be a little patient. I know, I'm sorry. Why did nobody remind me? Yeah, there we go. Today is the 4th. Arjun Singh, Shriram,